Philippine Civil Procedure, Question and Answer, Part 1. Question 1. How is the Philippine legal system characterized and what governs civil procedure in the country? Answer. The Philippine legal system is mainly based on civil law, but it also incorporates elements of American common law, making it a mixed system. Civil procedure is regulated by the 1997 Rules of Civil Procedure as updated by the 2019 amendments, along with various rules issued by the Supreme Court. Question 2. How is the civil court system structured and what are the different levels of appeal and specialist courts? Answer. The civil court system in the Philippines is structured with several tiers and specialized courts. The first level courts include MTCs or Metropolitan Trial Courts for metropolitan areas. MTCCs or Municipal Trial Courts in cities. This is for cities not in a metropolitan area. MTCs or Municipal Trial Courts. This is for municipalities. MCTCs or Municipal Circuit Trial Courts for group municipalities. Now, MTCs generally handle civil cases where the claim does not exceed 2 million pesos. They also have jurisdiction over cases involving real property where the value does not exceed 400,000 pesos. The regional trial court, present in each judicial region and consisting of various branches, act as first-level courts with broad jurisdiction over cases outside the scope of MTCs. They also handle appeals from MTCs. Some RTCs are designated as special commercial courts, family courts, special admiralty courts, and cybercrime courts. The Court of Appeals is divided into 23 divisions, each with 3 justices, and reviews appeals from the RTCs and quasi-judicial agencies. On the same level are 2 specialized courts, which are Sandigan Bayan, which handles cases of graft and corruption against government officials, and the Court of Tax Appeals, which manages tax and customs cases. At the highest level is the Supreme Court, comprising 15 members who sit en banc or in 3 divisions of 5 justices each. The Supreme Court reviews lower court judgments and checks for grave abuse of discretion by lower courts and government agencies. Additionally, Sharia courts operate in Muslim regions, handling cases related to the Muslim Personal Law Code, primarily covering marriage and inheritance issues. Question 3. What are the main stages of civil proceedings and how are small claims and summary procedures handled? Answer. The main stages in civil proceedings in the Philippines include, first, filing of complaint, issuance of summons, and exchange of pleadings. This stage generally takes 3 to 6 months. Next, referral to Stage 2 mediation, pre-trial, and discovery. This phase can last from 6 months to 1 year. Next, trial proper. Depending on the complexity of the case, the number of witnesses, and other factors, this stage can take anywhere from 6 months to 3 years. And finally, rendition of judgment. This final stage may take 6 months to 2 years. Although the rules of court prescribe specific periods for each stage, these timelines are often extended due to docket congestion. There are also expedited trial procedures for certain cases. We have the small claims cases, which involve the payment of money where the claim does not exceed 1 million pesos exclusive of interest and cost. We also have summary procedure. This applies to all other civil cases except probate proceedings, and where the total claim amount does not exceed 2 million pesos. It is also used in cases involving enforcement of barangay amicable settlements and arbitration awards exceeding 1 million, ejectment cases, and the revival of judgments from first-level courts. Question 4. How do courts handle exclusive jurisdiction clauses in contracts, and are there any exceptions? Answer. Exclusive jurisdiction clauses in contracts, which clearly indicate the party's intention to confer jurisdiction exclusively to another country, are generally recognized as valid by Philippine courts. However, even with these clauses, Philippine courts may still hear cases involving significant public interest, such as labor disputes. Additionally, a Philippine court may assume jurisdiction by applying the doctrine of forum non-convenience. Question 5. What are the typical costs involved in civil court proceedings, and how are these costs allocated between the parties? Answer. The cost of civil court proceedings include filing fees, legal fees for counsel, and fees for witnesses and commissioners when applicable. Generally, each party is responsible for their own costs, but the court may order the losing party to pay the cost of the suit. A standard filing fee of 2% of the total amount of the claim is imposed, and there are no current regulations on cost budgeting. Question 6. Are there specific rules on litigation funding, and are contingency fee arrangements allowed? Answer. There are no specific rules on litigation funding. Contingency fee arrangements, where a lawyer is paid a portion of the judgment proceeds if the case is won, are allowed as long as they do not become champertus agreements. These agreements are where the lawyer finances the litigation and receives a portion of the judgment as their fee. Question 7. Are there any restrictions on assigning a claim or cause of action? Answer. There are no restrictions on assigning a claim or cause of action, provided the new party has a genuine interest in the case. This means the new party must benefit from or be harmed by the judgment or be entitled to the outcomes of the suit. Additionally, while there are no specific rules on funding litigation, again, as said earlier, champertus arrangement whereby a lawyer finances the litigation and receives a portion of the judgment are prohibited. Question 8. How can a party secure assets during pending litigation to ensure potential judgment satisfaction? Answer. During pending litigation, a party can secure assets by requesting a writ of attachment. This provisional remedy allows the property of the opposing party to be seized and held as security for any potential judgment, including legal costs, that the court may eventually award. The attachment can be requested on specific grounds, such as the risk of the adverse party absconding or disposing of assets to avoid satisfying the judgment. This ensures that there are assets available to fulfill any potential judgment, providing financial security for the plaintiff. Question 9. Are there any specific formalities that must be followed before initiating a legal proceeding? Answer. No particular formalities are required before initiating a legal proceeding. Previously, failing to meet a condition precedent could result in the dismissal of a complaint. However, the 2019 amendments to the rules of court have changed this. Now, a motion to dismiss based on not fulfilling a condition precedent is no longer allowed. This means parties can proceed with their case even if certain preliminary conditions were not initially met. Question 10. What are the time limits for filing legal cases, and can actions be barred before these limits? Answer. The time limits for filing legal cases, known as prescriptive periods, are usually determined by substantive law and can range from 1 year to 30 years from when the cause of action arises. Generally, there is a 5-year prescriptive period for most actions unless a specific period is set by law or rules. Additionally, actions can be barred by laches even before the prescriptive period expires if the court determines that the party has been neglectful or has delayed too long in enforcing their rights, making it unfair to allow the claim. Question 11. What happens after the initial pleading is filed in a civil case? Answer. After filing the initial pleading, the court examines it to determine if it is dismissible. If it is not dismissible, the court issues a summons within 5 days, instructing the other party to file a response within 30 days. Question 12. What are the methods for serving summons within the Philippines? Answer. Summons can be served in person by handing it to the defendant, or if refused, by tendering it to them. For justifiable reasons, substituted service is allowed by, first, leaving copies at the defendant's residence with a person of at least 18 years old. Second, leaving copies at the defendant's workplace with a competent person. Third, leaving copies with officers of the Homeowners Association or the chief security officer of the defendant's building. Fourth, sending an email to the defendant's email address if the court permits. Question 13. How is a summons served to defendants outside the Philippines? Answer. For defendants outside the Philippines, extraterritorial service is applicable when the action affects the plaintiff's personal status, involves property in the Philippines, or involves the defendant's attached property. This service can be done by, first, personal service. Second, publishing the summons in a general circulation newspaper and sending a copy to the defendant's last known address. Third, following international conventions to which the Philippines is a party. And fourth, any other method the court deems sufficient. Question 14. How is a summons served to a foreign private juridical entities? Answer. For foreign private juridical entities, service can be done by, first, personal service through the foreign country's court with the Department of Foreign Affairs help. Second, by publishing in a newspaper of general circulation in the defendant's country and sending a copy by registered mail. Third, facsimile. Fourth, electronic means with proof of service. And fifth, any other method the court directs. Question 15. What are interim remedies and when are they typically available in legal proceedings? Answer. Interim remedies are temporary measures granted by a court to safeguard the rights of parties during the pendency of a case. These measures, such as preliminary injunctions and the appointment of a receiver, aim to prevent irreparable harm and maintain the status quo until the case is resolved. Generally, interim remedies are available once a case has been filed in court. Question 16. How can parties utilize interim measures if there is an arbitration agreement in place? Answer: if there is an arbitration agreement, parties can request interim measures of protection from a court before the arbitral tribunal is established. These interim measures may include seeking a preliminary injunction or appointing a receiver to manage disputed property or asset. This allows parties to secure their interest and prevent potential harm pending the arbitration process. Question 17. What essential elements must be included in a complaint filed in court? Answer: when filing a complaint in court, it is crucial to include the ultimate facts constituting the plaintiff's cause of action. This means outlining the specific claims against the defendant, including details such as names and residences of both parties involved. Question 18. What is the significance of verifying a complaint in legal proceedings? Answer: verifying a complaint involves the plaintiff swearing under oath, usually in the form of an affidavit, that the allegations in the pleading are true and correct to their personal knowledge or based on authentic records. This verification helps ensure the credibility and authenticity of the claims made in the complaint. Question 19. What is a certification against forum shopping and why is it required in legal pleadings? Answer: a certification against forum shopping is a sworn statement by the plaintiff declaring that no other similar action or claim involving the same issues has been filed in any other court or tribunal. This certification is mandatory to prevent litigants from filing multiple cases in different courts, which could lead to conflicting decisions and judicial inefficiencies. Question 20. What document must be attached to a complaint if it is based on an instrument or document? Answer: if a complaint is based on a specific document or instrument, the substance of that document must be included in the pleading. Moreover, the original or a copy of the document should be attached as an exhibit to support the claims made in the complaint. Question 21. What are the requirements regarding witnesses and evidence in a claimant's pleading? Answer: in a claimant's pleading, it is necessary to list the names of witnesses along with a summary of their intended testimonies. Judicial affidavits of these witnesses and documentary or object evidence supporting the allegations must also be provided. Generally, additional witnesses not initially included in the pleading may only be admitted under exceptional circumstances. Question 22. When can pleadings be amended during legal proceeding and what conditions apply? Answer: pleadings can be amended before a responsive pleading is served as a matter of right. This allows parties to correct errors or add new information without needing court approval. However, after a responsive pleading is filed, which typically includes responses like answers or counterclaims, formal amendments to pleading can still be made at any stage of the case provided that they do not unfairly prejudice the other party. However, substantial amendments after a responsive pleading requires permission from the court, ensuring fairness and preventing undue disadvantage to the opposing side. Question 23. Can pleadings be withdrawn during legal proceedings, and what are the conditions for doing so? Answer. In legal practice, pleadings can typically be withdrawn without needing court permission before the opposing party files a response. If withdrawal occurs before any response, court approval is generally not required, provided it does not prejudice the other party. However, if a response has already been filed, withdrawing pleadings requires the plaintiff to seek leave of court. In such cases, the court may dismiss the claim with prejudice, meaning it cannot be refiled depending on the circumstances of the case. So that's it. Some questions and answers on the civil procedure under Philippine law. If you find this video useful, please don't forget to like, share, and subscribe. Thank you very much.